friends. Today in this video lecture, we will understand the basics of refugee law in general and the Indian refugee protection system specifically. We shall dwell upon the reasons as to why the Indian government is hesitant in bringing a refugee law and do away with the practice of referring the refugees as foreigners. In this lecture, we shall also see as to what are the laws that are taken into consideration when the matters come for refugees. Throughout the world and over the centuries, societies have welcomed frightened, weary strangers and the victims of persecution and violence. This humanitarian tradition of offering sanctuary is often now played out on television screens across the globe as war and large-scale persecution produce millions of refugees and internally displaced persons. Yet, even as people continue to flee from threats to their lives and freedom, governments are, for many reasons, finding it increasingly difficult to reconcile their humanitarian impulses and obligations with their domestic needs and political realities. At the start of the 21st century, protecting refugees means maintaining solidarity with the world's most threatened while finding answers to the challenges confronting the international system that was created to do just that. It should be appreciated that a person becomes a refugee because of circumstances which are beyond that person's control, often poignant. He or she is left with no other option but to flee from human rights violations, socio-economic and political insecurity, generalized violence, civil war or ethnic strife, all these leading to fear of persecution. The import of this observation would be evident when one looks at the definition of a refugee. The term refugee has a particular meaning in international law, and its legal definition is laid down in the United Nations 1951 Convention relating to the status of refugees and its 1967 protocol. Article 1, para 2 of the 1951 Convention defines the refugee as a person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable or, owing to such fear, unwilling to avail himself of the protection of that country. Therefore, the need to give due importance to humanitarian and human rights aspects in dealing with refugees cannot be overstressed. Thus, it may be noted that there are well-defined and specific grounds which have to be satisfied before a person can qualify to become a refugee. These grounds are well founded on fear of persecution and consideration of a number of factors which may operate individually or collectively of persecution, and consideration of a number of factors which may operate individually or collectively. What needs discussion in this backdrop is whether India upholds the sanctity of Refugee Convention or not. The international obligations to protect refugees, including non-refoulement, non-expulsion or non-extradition, and the minimum standard of treatment are traced in customary international law as well as in international treaty law in the form of United Nations Convention relating to the status of refugees 1951 along with the protocol of 1967. India is neither party to the 1951 Convention on Refugees nor the 1967 protocol. The lack of specific refugee legislation in India has led to the government to adopt an ad hoc approach to different refugee influxes. The status of refugees in India is governed mainly by political and administrative decisions rather than any codified model of conduct. The ad hoc nature of the government's approach has led to varying treatment of different refugee groups. Some groups are granted a full range of benefits, including legal residence and the ability to be legally employed, whilst others are criminalized and denied access to basic social resources. The legal status of refugees in India is governed mainly by the Foreigners Act 1946 and the Citizenship Act 1955. These acts do not distinguish refugees fleeing persecution from other foreigners. They apply to all non-citizens equally. Under the acts, it is a criminal offence to be without valid travel or residence documents. These provisions rendered refugees liable to deportation and detention. However, India is a signatory to various other international humanitarian instruments such as the Universal Declaration of Human Rights and the International Convention on Civil and Political Rights, which set out principles of universal human rights. Therefore, despite being a non-signatory to the Refugee Convention, India has an obligation under international law to protect asylum seekers, which it has traditionally honoured. India is also a member of the Executive Committee of UNHCR, which reviews and approves the agency's programs and budget and advises on international protection. Though India does not have a national framework on refugee law, in 2006, the Supreme Court of India ruled that the right to life and personal liberty as enshrined in Indian Constitution protects refugees from forced repatriation. India's status as a preferred refugee haven is confirmed by the steady flow of refugees from many of its subcontinental neighbours as also from elsewhere. India continues to receive them despite its own over a billion population, with at least 600 million living in poverty with limited access to basic amenities. However, the Indian legal framework has no uniform law to deal with the huge refugee population and has not made any progress towards evolving one either. Until then, it chooses to treat incoming refugees based on their national origin and political considerations, questioning the uniformity of rights and privileges granted to refugee communities. Indeed, the National Human Rights Commission has submitted numerous reports urging the promulgation of a national law, or at least making changes or amendments to the outdated Foreigners Act 1946, which is the current law consulted by authorities with regard to refugees and asylum seekers. The primary and most significant lacuna in this law is that it does not contain the term refugee. Consequently, under Indian law, the term foreigner is used to cover aliens temporarily or permanently residing in the country. This places refugees along with immigrants and tourists in this broad category, depriving them of privileges available under the Geneva Convention. During the discussion on the adoption of the convention, Indian representatives averred that India was not convinced that there was a need to set up an elaborate international organization whose sole responsibility would be to give refugees legal protection. After the adoption of the convention, there has been no official response from the Government of India on its refusal to ratify the convention, except for a statement by the External Affairs Minister in Parliament, which indicated that the government was studying the implications of ratifying it. Without a specialized governance regime for country of his former habitual residence, as a result of such events, is unable or owing to such fear is unwilling to return to it. The unrestricted power of the executive to remove foreigners was first confirmed by the Supreme Court in Hans Müller of Nuremberg, AIR 1955, SC 367, where it held that the Foreigners Act confers the power to expel foreigners from India. It vests the central government with absolute and unfettered discretion, and as there is no provision of fettering this discretion in the Constitution, an unrestricted right to expel remains. The untrammeled right of the executive to remove foreigners from India has been upheld by the Supreme Court in a number of subsequent decisions, like Louis D. Rate 1991 3 SCC 554 and Sarbananda Sonowal 2005 5 SCC 665. In this backdrop, let us now see how the Indian judiciary has played an important role in preserving the rights of these so-called foreigners. Indian judiciary is the guiding sentinel which preserves the rule of law. So, in a recent case before Supreme Court as to Chakma refugees from Bangladesh in National Human Rights Commission versus State of Arunachal Pradesh 1996 1 SCC 742, wherein the Supreme Court has laid down that the State of Arunachal Pradesh was under constitutional obligation to protect and safeguard the life, health and well-being of Chakmas. So, the courts directed the state to take measures necessary for ensuring life and personal liberties of Chakmas. The Supreme Court held that Chakma refugees who had come from Bangladesh due to persecution when Bangladesh was under Pakistani rule cannot be sent back to Bangladesh, as they may be killed there and thus be deprived of the right to life under Article 21. The state was directed to protect each and every Chakma and repel any attempt to drive them out of the state, and India is expected to respect international treaties and convention of humanitarian law. However, in Sisuwala Pal versus Union of India AIR 1989 MD 254, in this case the petitioner, who was admittedly refugee, had entered India in 1971 from East Pakistan, now Bangladesh, were claiming themselves to be Indian citizen on the basis of their long stay in India and being said to be relatives of some Indian citizens. The petitioners had not shown what step they had taken for acquisition of Indian citizenship. It was held that mere long stay which was unauthorized did not confer citizenship rights. The petitioners were permitted to enter into India as refugees. In Arunachal Pradesh versus Khudiram Chakma AIR 1994-1461, it was stated that Chakmas are foreigners in accordance with Citizenship Act 1955, and therefore they are not entitled to all fundamental rights enshrined in Part 3 of the Constitution. The right to enjoy asylum has to interpret in the light of instrument as a whole. It implies that although an asylum seeker has no right to be granted admission to a foreign state, equally a state which granted him asylum must not later return him to country. Thus, one can see the divergent views taken by the executive and the judiciary trying to protect the interests of the refugees in India. With this, we come to an end of the video lecture on refugee law in India. Hope you enjoyed watching the same. Thank you.